the opinion of others consume you. Yeah, happy birthday to baby Lika.
Today's Black Law's dictionary word is presumption. Let's go. An inference in favor of a particular fact. Presumption. A presumption is a rule of law, statutory or judicial, by which finding of a basic fact give rise to existence of presumed fact until presumption is rebutted. Van Wart versus Cook, OKL.APP.557P.2D.1161, 1163. A legal device which operates in the absence of other proof to require that certain inferences be drawn from the available evidence. Port Terminal and Warehousing Company versus John S. James Company, D.C.G.A.92F.R.D.100, 106. A presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. A presumption is either conclusive or rebuttable. Every rebuttable presumption is either A, a presumption affecting the burden of producing evidence, or B, a presumption affecting the burden of proof. Calif.evd.code, subsection 600. In all civil actions and proceedings not otherwise provided by Act of Congress or by the Federal Rules of Evidence, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption, but does not shift to such party the burden of proof in the sense of the risk of non-persuasion, which remains throughout the trial upon the party on whom it was originally cast. Federal Rule of Evidence 301. See also disputable presumption, inference, juris et de jure, presumptive evidence, prima facie, raise a presumption. Black's Law Dictionary, 6th edition, page 1185. All presumptions that prejudice or injure protected rights are a violation of due process of law that results in a void judgment. Black's Law Dictionary defines due process as follows. Due process of law, law in its regular course of administration through courts of justice. Due process of law in each particular case means such an exercise of the powers of the government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribed for the class or cases to which the one in question belongs. A course of legal proceedings according to those rules and principles which have been established in our systems of jurisprudence for the enforcement and protection of private rights. To give such proceedings any validity, there must be a tribunal competent by its constitution, that is, by the law of the creation, to pass upon the subject matter of the suit, and if that involves merely a determination of the personal liability of the defendant, he must be brought within its jurisdiction by service of process within the state, or his voluntary appearance. Penior versus Neff, 95 U.S. 714, 24, L.ed.F.565. Due process of law implies the right of the person affected thereby to be present before the tribunal which pronounces judgment upon the question of life, liberty, or property in its most comprehensive sense, to be heard by testimony or otherwise, and to have the right of controverting by proof every material fact which bears on the question of right in the matter involved. If any question of fact or liability be conclusively presumed rather than proven against him, this is not due process of law. How courts abuse presumption to destroy your constitutional rights. Overview of abusive techniques of courts and government prosecutors. The abuse of presumption to injure your rights and transfer them to the government unlawfully is accomplished by the following devious techniques by judges and lawyers in litigation against the government. Making presumption into evidence. Presumptions are not evidence and cannot serve as a substitute for evidence. This essentially turns the court into a religious body, whereby presumption serves as a substitute for religious faith. Using words of art in combination with the word includes, and then violating rules of statutory construction to add things to definitions of words that aren't there in order to bring you within their jurisdiction. C. Legal deception, propaganda, and fraud. Form number 05.014. A website, sedm.org/forms/formal, FOML, index.htm. Form index. So we'll repeat that again. HTTP. sedm.org/forms/forms/FORMS/FORMINDEX.htm. Number 3. Presuming that you are engaged in some type of franchise based on the words they use to describe you. This violates the presumption which is the foundation of American jurisprudence, which is the presumption of innocence until proven guilty. Addressing you as a person, quote unquote, comma, a natural person, quote unquote, or, comma, an individual, quote unquote, all of whom are public officers in the government. See that same website that was quoted above. Presuming that a statute is, number 5, presuming that a statute is public law that applies equally to everyone, including non-residents and those who do not consent to participate. Most federal law, in fact, is private law that only applies to those who consent to participate in writing. For instance, the entire Internal Revenue Code, Subtitle A, is private law that only applies to those domiciled in the District of Columbia and engaged in a public office in the government. All others are identified as a foreign estate meaning not exempt, but rather not subject to the franchise agreement. Purpose of due process, to completely remove presumption, quote unquote, from legal proceedings. All presumption which prejudices a right guaranteed by the Constitution represents a violation of constitutional due process. Thank you for being here today on Black's Laws. Word of the day is presumption. Appreciate the love. KingKoolie.